Your reaction to the rulings?
Well, this is what we expected, is what we argued, so I believe the decisions were correct. Everything that we expected.
Expectations of the constitutional consequential?
I hope the president and leader of the opposition can agree that we have maybe a new chairman from one of the lists within a very short time, and that elections maybe in 28 days, that would be reasonable. So hopefully they can agree.
28 days?
Or less.
Have you communicated with the leader of the opposition, and how do you see the two gentlemen meeting from now on?
Before I get there, I want to say that the people of Guyana and democracy have triumphed, and the Constitution has triumphed today. As I said from the beginning, this case should never have been filed. It was a waste of resources, a waste of time. Fortunately, we have come to the end. And fortunately, the court, in its wisdom, has seen it fit to fix a date and time for us to at least try and come back and work out some kind of arrangements in terms of the consequential orders. I think the court has made a clear hint of where it is going in the absence of an agreement in that respect, because the court said that the Constitution itself has set out certain guidelines, and the president of the court, in his summary just now, indicated that is more expressly and elaborately stated in the judgment. What the court is really hinting at there is that in the absence of an agreement, the court will have to take the initiative, and the court doesn't really want to do that, to make coercive orders for early elections. So this shenaniganism that's taking place at GECOM with house verification will have to be stopped, and the Constitution will have to be given effect to, which is early elections.
Would you think a new chairman at this point in time would be the right thing?
Well, that is one. Well, the chairman's appointment has already been declared to be unlawful. So that is a given. That's where we have to start from. Whether it's a right thing or a wrong thing, we can't question that. An unlawful act cannot be countenanced. So the chairman will have to go. And that is why the judge, at the end of his ruling in that matter, specifically said that he must be addressed, or the court must be addressed on consequential orders. Meaning that I believe the court recognizes strategies of dilation and delay which have preoccupied this process, and the court is indicating that it may be influenced to order time frames within which a next chairman is to be appointed.
But your attorney had said at the CCJ when they
that was a very
yes, that you're willing to set aside the temporarily.
I don't think in the way that the court has ruled here in this firm way, I don't think that the court will entertain. A court has declared an act to be unlawful. You can't ask the court to continue that unlawfulness in office. It's against the law. I can't imagine that the court will want to, that kind of thing. But so we will have to deal with those issues at the consequential order level.
All things being equal, how soon do you anticipate we can head to the court?
You think 28 days sufficient?
Well 28 days was offered by one of
the court has indicated that it must give effect to the letter and spirit of the Constitution. The 3 months that the Constitution prescribed has already expired. The least that the court can do in the circumstances is to come up with the shortest period of time, not to frustrate the Constitution further.
Any demands the leader of the opposition would have when he meets with the president? It's obvious that the two of them have to meet now.
I can't speak for the leader of the opposition. Of course, he will speak on this matter very shortly, before the end of today, I have no doubt.
Member of the National Assembly, lawyer for Sharon Prasad Sanji Jatadan. Mr. Jatadan, reaction to the court's ruling?
It's the ruling. Of course, we find favor with it. We've been saying all along, I think everybody in Prep B knows that 33 is the lowest minimum of 65. Reason has been restored to its throne with that. We had also argued that if you wanted to challenge my client, Mr. Charandas's appointment into Parliament, you had 28 days which to do. We're very pleased that the court expressly agreed with that. As it relates, we're not specifically involved, but we do believe that the unilateral appointment was bad, it was retrograde, it was a reversal of things, it was representative of what we were trying to avoid, that there be some consensus. So these are all the things. Where do we go from here? Hopefully, what it is a process that is quick, for the appointment of a new chairman. Parliament should be dissolved now. The President should dissolve Parliament, and we should go to an election. This is what it is. This is what it is. We play by rules. If we're not happy with the rules and we decide to stay away, then where does that leave us? Because the next time it might be the people who are currently in opposition not liking it, and they would want to bend it. Then what happens? The average citizen, you and I, need that our leaders must obey the law. It's very clear.
Have you been able to communicate with your client since? Any reaction to what?
I have communicated to my client when I was in the court to tell him of the decision. He has been watching it. I'd sent him the link while we were in the courtroom. His comments were he is pleased with the ruling. He was confident of what he had done. He had confidence of what he had done was lawful. He's relieved that the court has also said that is so. There have been various issues about the 33, 34. As you would know, that didn't specifically relate to him. That was more a mathematical issue. But how could 34 be the required majority? The travesty that the Court of Appeal in Guyana thought that was so.
Would he be coming back to Guyana now? Because he had indicated that after the ruling he would return.
He still has a home here. He still has his family members here. I have no doubt that he would at some point in time return to Guyana. I can't tell you when that will be.
I'm completely disappointed with the decision of the court. As my colleagues would have mentioned, we felt that our arguments were sound and ought to have been upheld by the court. But that is the position of the court. We have to return on the 24th in terms of the consequential orders that the court would make. So we would better be in a position to see what are the consequences in terms of what is practical at that stage on the 24th.
At this point, what do you think is practical?
I can't say, because we have to wait for what is going to be the proposals coming from both sides.
One of the lawyers suggested 28 days for elections to be held. What are your thoughts on that?
Well, if we're talking about practicality and what's reasonable, I can't see how that could ever be possible, having regard to the system and what needs to be done, and the need for the list to be properly sanitized and prepared.
At the CCJ, when the oral arguments were presented, the national attorney would have been, the opposition leader attorney would have indicated that maybe they could set aside the ruling temporarily with respect to the chairman appointment and allow for elections to be held. What are your thoughts on that?
I find that a very strange position, or strange proposition. We cannot on one hand knock down something as unconstitutional and then the court being a party to saying that it is valid at the same time.
AG, your reaction to the ruling, and how quick are we expecting
well,
to see the two leaders?
It's the ruling of the final court, and as we said previously, we accept the ruling. The decision, of course, we haven't read the judgment, so we're trying to get the judgments to give a more detailed response. But as you know, in the case of the GECOM chair, the court said it was flawed, the decision was flawed. And so, when reading the judgment, if they say it's flawed, it meant that the chair was not validly appointed. So let's get the judgment and read it, because of course if it means that it's flawed, there are other considerations, as you know. And the no-confidence motions, the court knocks us down on every point conceivable.
Have you communicated the decision or the ruling to the President as yet, and how soon can we?
And I'm sure after he meets with me, when he comes down, he would meet with the press.
What other considerations were you talking about when it comes to the appointment of the chairman? Is it
well,
that
you can work that out, but you can work that out. I don't want to venture nothing. Let's read the judgment.
All the decisions of GECOM under his chairmanship, that type of thing?
No, I don't think so. I don't think so.
Sir, what is the general feeling today as you heard the rulings?
Well, the final court has spoken. There's no other course of appealing, etc. So we said we would abide by the judgment.
Outside of your current post, you're also part of a major party. Do you see elections this year?
I don't want to venture those things. You would recall that GECOM had indicated the elections in November at their last position to the president. So all these things will have to be reviewed. We don't know if the CCJ would venture into making any determination in the matter, etc. They asked us to give on the 24th. And we would expect that the appellants would make proposals to us in terms of what they think should happen. But we don't want to, we're not in a position to go further than that. You have other members of the team, I don't know if you would.
Mr. Costa, general reaction to what
I am disappointed in the decision. I thought we had winnable arguments, but the court on the two issues that I dealt with in relation to Compton Reed. One, the issue of Charan Das' disqualification to be a member of Parliament. The court has said they don't have jurisdiction to deal with that issue because the Constitution has set out a way in which it is done. Under the National Assembly Validity of Election Act, you have to challenge his disqualification within 28 days after the election was certified. And our challenge came over 3 years after the election was certified. So they don't have jurisdiction. In relation to Compton Reed, they said, a majority at the court said, listen, 156.3 is separate and distinct. It has no connection to 1066. But if Charan Das' vote was not to be counted, then the Constitution should have provided expressly that if a member votes against his list, then his vote is invalid. In the absence of that, they have not seen that 156.3 prevents him from voting against the list. He does so with the consequence that he will be recalled. Justice Anderson was in sympathy. He says this is a difficult situation. He can't understand, but that is the law. Justice Lee also feels that crossing the floor, it could not be the intention of the framers of the Constitution that a person who crossed the floor vote should be invalid. The Constitution must provide expressly for that. And that is why they did not consider Charan Das' vote as invalid, because it were two limbs. One, invalidity because he voted against the list, or alternatively, he was not qualified to be a member. So on both limbs, they knock us down.